What you're about to witness is not a trial. It's a moment where a single decision reshapes an entire life. A 21-year-old defendant, 2 serious felony charges, and a courtroom walking carefully through consequences that could last forever. This hearing isn't about debating guilt, it's about understanding power, pressure, and the irreversible weight of a no-contest plea. Every question matters. Every answer carries consequences. Stay focused because once this plea is entered, there's no turning back.
This matter comes before the court at this time for an anticipated plea hearing. This court has been provided with a copy of a third amended information, or it also has an acknowledgement of rights and plea agreement, at least a draft of such agreement currently before it. I trust, Mr. Watts, that it is your client's intention to follow through with the terms of the plea agreement in this case.
That is correct, Your Honor. And you mentioned a moment ago a draft agreement. The agreement I have in front of me is signed by myself and Mr. Mader on 30 December at the jail. I forwarded that signed agreement to Ms. Pierce, which I presume she signed as well, and then forwarded to Your Honor.
All right.
This is a critical legal moment. The court confirms that the defendant is entering a no-contest plea, not pleading guilty, and that distinction is important. A no-contest plea allows the court to convict without the defendant admitting the facts. It's often used when evidence is strong and the defense wants to limit future exposure, especially in civil matters. But make no mistake, the outcome is the same as a guilty plea: conviction, sentencing, and a permanent criminal record. The question is certainty safer than risk?
Importantly, I believe that it's the understanding of the parties that the defendant would be agreeing to plead to an amended count 1, level 1 person felony, and that would be a no contest plea as I understand it, and then also to an amended count 2, aggravated indecent liberties. He'd be pleading no contest to that level 3 person felony. Is that consistent with your understanding, Mr. Watts?
It is, Your Honor.
And yours, Ms. Pierce?
Yes, Your Honor.
Importantly, Mr. Mader, you've heard the discussion so far here on the record. It would be the court's understanding that based on the plea agreement that's been reached in the case, you would now be entering pleas of no contest to level 1 person felony and also a count of aggravated indecent liberties with level 3 person felony. Is that indeed your intention?
Yes, Your Honor.
All right, I've got a number of questions I need to ask you regarding taking of pleas of no contest. If there's anything along the way that you don't understand, I would give you the opportunity to confer privately with your lawyer in a breakout session at any point. Just let the court know if you need that time to get further private advice, okay?
Okay. Yes, Your Honor.
State your full legal name for the record.
Matthew Allen Mader.
How old are you right now?
21.
Okay. What's the highest level of education that you've attained?
12th grade.
Now, do you believe we're going to have difficulty understanding any of the legal concepts we're going to be discussing in court here today?
I don't know.
Okay, well, if you do, again, I'll give you the opportunity to get clarification either from the court or further advice from your attorney, all right?
Yes, Your Honor.
Mr. Mader, have you ever been adjudged to be mentally ill?
No, Your Honor.
Are you currently under the influence of alcohol or any drug?
No, Your Honor.
Are you currently taking any type of prescription medication?
No, Your Honor.
So do you believe your mind is clear today, that you have a full understanding of what's going on here in court?
Yes, Your Honor.
Did you receive a copy of the third amended information?
Yes, Your Honor. I got it with me right here.
All right. Do you understand the nature of the charge in count 1, level 1 person felony?
Yes, Your Honor.
Do you understand the nature of the charge in count 2, aggravated indecent liberties?
Yes, Your Honor.
Mr. Mader, I know sometimes you're anxious to answer, but allow me to complete my question before you begin to answer it, okay?
Okay.
You understand, Mr. Mader, that when you enter pleas of no contest, you are not necessarily admitting that you did these acts, but you're also not contesting that you be convicted of these charges just the same. You understand that?
Yes, Your Honor.
You also understand that when you enter pleas of no contest, you give up any legal defenses that you might have had to these charges.
Yes, Your Honor.
Are you aware that in a trial, the state must present evidence against you in open court, that any witnesses must testify in open court in your presence, that you have the right to cross-examine witnesses with the assistance of your lawyer, and that you can present evidence at your trial on your own behalf and subpoena your own witnesses to court?
Yes, Your Honor.
You also understand that at such a trial, you personally would have a privilege against self-incrimination, which means that if you wanted to testify in your case, you could at your choice, but no one could force you or compel you to testify against yourself if you did want to. Do you understand that?
Yes, Your Honor.
Mr. Mader, you understand that when you enter pleas of no contest, you give up these valuable trial rights that the court has described.
Yes, sir.
This is where the courtroom becomes deadly serious. The judge methodically explains every constitutional right being surrendered: jury trial, cross-examination, presenting evidence, and the right to remain silent without consequence. Once a no contest plea is entered, these rights disappear forever. Judges do this carefully to prevent future appeals claiming confusion or coercion. This moment locks the legal door shut. And it raises an important question for viewers. Do defendants truly understand what they're giving up?
Your Honor.
You also understand that you have a right to a trial by jury, and that before you could be found guilty, that jury would have to be satisfied as to your guilt beyond a reasonable doubt.
Yes, Your Honor.
You understand that when you enter pleas of no contest, you give up your right to a trial by jury and the requirement that you be found guilty beyond a reasonable doubt.
Yes, Your Honor.
Mr. Maynard, you understand that you have a right to appeal a guilty verdict if you have a trial.
Yes, Your Honor.
You further understand that you may appeal your sentence after entering pleas of no contest, but generally you may not appeal judgments of conviction after entering such pleas.
Yes, Your Honor.
Now, are you aware of the possible penalties that can be imposed as a result of these no contest pleas that you're attempting to make?
Yes, Your Honor.
Well, let's go over those. Starting with the charge in count 1, a level 1 person felony. In the most favorable criminal history category of I, you could receive as little as a 147-month sentence. In the worst criminal history category of A, you could receive up to a 653-month sentence. So the sentencing range is 147 to 653 months in prison, depending on your criminal history. As you sit today, we do not know with certainty what your criminal history is. You, better than anyone else here, really should know what your criminal record looks like, but that will be researched by the Court Services Department. And based on the outcome of their research as of the date of your sentencing, that determines where you fall along the level 1 line, and then you'd be sentenced accordingly. You understand that?
Yes, Your Honor.
All right. Aggravated indecent liberties with count 2 is a level 3 person felony. On level 3, in the most favorable criminal history category of I, you could receive as little as a 55-month sentence. In the worst criminal history category of A, you could receive up to a 247-month sentence. So the sentencing range on that count is 55 to 247 months in prison, again, depending on your criminal history. Also, I need to point out to you that there's 2 different ways that these charges can be handled at sentencing. One would be concurrent sentencing, and one is consecutive. Do you know the difference?
Yes, Your Honor.
We're going to talk about that too now. Concurrent sentences run all together, which means that if you were serving one charge, you'd also be serving the time on the other charge, obviously resulting in a shorter prison sentence. Consecutive sentences, as I think you know, are back-to-back, boxcar. You'd serve all of one before you even start the other, which obviously would result in a longer prison sentence. Mr. Maynard, generally, it's up to the court at sentencing to determine whether these counts run consecutively or concurrently. You understand?
Here's where the scale of this case becomes undeniable. The sentencing range alone spans from years to decades, depending on criminal history. Add to that the possibility of massive fines, lifetime post-release supervision, and mandatory offender registration. Even after prison, the punishment doesn't end. Housing restrictions, employment barriers, and permanent public records follow for life. This isn't just incarceration, it's a lifelong legal identity. Should the justice system impose consequences that never truly expire? That debate continues far beyond this courtroom.
Yes, Your Honor.
You also understand that on both counts 1 and 2, you could receive up to a $300,000 fine on each count.
Yes, Your Honor.
In addition to any fine, are you aware that you could be assessed and required to pay court costs, certain fees, including reimbursement of legal fees and expenses, and restitution to victims, if any are owed, as part of your sentencing orders?
Yes, Your Honor.
Mr. Maynard, I also want to point out to you that at levels 1 and 3, these are presumptive prison offenses under Kansas law, regardless of your criminal history. Do you know that?
Yes, Your Honor.
Counsel, in the draft version that I have for me, I don't see that the issue of possible departure was addressed specifically. Is there an agreement regarding departure?
Yes, no departures will be sought.
Mr. Watts, do you agree with that?
That is our understanding as well, Your Honor.
All right. Mr. Maynard, the law does allow for special exceptions to general rules called departure. They have to be based on substantial and compelling reasons. It would be discretionary with the court whether that departure would even be granted. It's my understanding that as part of the plea agreement, you've waived filing any departure motions or even arguing for that exception. Do you acknowledge that?
Yes, Your Honor.
Okay. And that was part of the favorable plea agreement that you received. Isn't that correct?
Yes, Your Honor.
You also understand that upon conviction of these offenses, you'd be facing post-release supervision, which is your state parole time that you do after you get out of prison for the remainder of your life.
Yes, Your Honor.
And that it's the court's understanding that pursuant to the terms of the plea agreement, that for the purpose of lifetime post-release supervision only, you are agreeing that you were over the age of 18 at the time of the offenses.
Yes, Your Honor.
Mr. Mader, do you believe that you've had an adequate opportunity to discuss all of your legal matters with your attorney, James Watts, before proceeding here today?
Yes, Your Honor.
Are you satisfied with the services and advice given to you by James Watts?
Yes, Your Honor.
Mr. Mader, do you understand if you're to be convicted of these offenses, you'd be subject to lifetime offender registration once you get out of prison?
Yes, Your Honor.
Okay. And you would be required to register, obviously, as an offender. Do you understand that?
Yes, Your Honor.
Now, Mr. Mader, this set of no contest pleas that you are attempting to make, have they been based upon any threat or promises as to what this court will do in regards to your sentence or any other type of threat or promise?
No, Your Honor.
Okay. Is there anything else that you thought was part of this plea deal that hasn't been accurately discussed either in your plea agreement document or here on the record?
No, Your Honor.
You understand, Mr. Mader, that there are any plea deals between your counsel and the county attorney's office regarding sentencing recommendations, that this court is not bound by any agreements made. The court may and shall consider them as recommendations, but is not bound by them. Do you understand that?
Yes, Your Honor.
So let me ask you formally, how do you plead to count one of the third amended information, a level 1 person felony?
Not guilty. Or guilty,
Okay.
sorry.
Okay, it's my understanding your plea is no contest. Is that?
Yeah, no contest, sorry.
Yeah. And then your formal plea to count 2, aggravated indecent liberties with.
No contest.
I'll ask the state to provide a concise statement of factual basis using victim initials only, obviously.
Thank you, Your Honor. Your Honor, on or about December the 6th of 2024, the victim RRO's mother and stepfather contacted the El Dorado Police Department to report that the victim in this case, RRO, reported to the mother that Mr. Mader, who is the stepfather's nephew, had been touching her. Mr. Mader lived with them during the time of the events here in El Dorado, Kansas. Thereafter, the was interviewed at the Sunlight Advocacy Center. During that interview, RRO reported that Mr. Mader had in fact touched her on her breast, that it had been under her shirt with his hand. He also touched her in the area of her area, and he rubbed her there, and it was outside of her underwear. Those events occurred, all of these events occurred in November of 2024 up into Thanksgiving Day, which would have been November the 28th of 2024. So as to count 2, the facts that I just recited in that the defendant touched the child on her breast and put his hands also on her area, rubbing under her pants, and that occurred in her bedroom here in El Dorado. RRO additionally described the last event, which was Thanksgiving Day, that occurred in the same place and the same house in El Dorado, and that the defendant was sucking on her, touching her in her area, and that he did so underneath her clothing and touched her on her area and went inside of her area at the time of the touching. Again, that occurred in her bedroom in the El Dorado area, Your Honor.
How old was the you referred to at the time of these incidents?
At the time she was.
Very well. All right, Matthew Allen Mader, do you now freely, knowingly, and voluntarily enter pleas of no contest and accept conviction for count 1 of the third amended information, level 1 person felony?
Yes, Your Honor.
Do you also enter a plea of no contest to aggravated indecent liberties with a level 3 person felony?
Yes, Your Honor.
Mr. Watts, as defense counsel, do you know of any legal reason why the court should not accept your client's plea?
No, sir.
Ms. Pierce, as prosecuting attorney, are you aware of any legal reason why the court shouldn't accept Mr. Mader's pleas?
No, Your Honor.
Matthew Mader, are you aware of a legal reason or any other good reason why the court shouldn't accept your pleas of no contest here this morning?
No, Your Honor.
The court will accept the no contest pleas made by Matthew Mader and finds that those pleas are made voluntarily. He has an understanding of the nature of the charges against him and the consequences of the pleas, and a factual basis for each of the 2 counts does exist. The court finds him therefore guilty and adjudges him therefore convicted by acceptance of his no contest pleas to count 1, a level 1 person felony, count 2, aggravated indecent liberties with a level 3 person felony. The 3rd count of the original information has been dismissed. Court orders a pre-sentence report be completed to accurately determine Matthew Mader's criminal history. Court will set an appropriate date for sentencing.
We have February 27th at 11 a.m.
All right, February 27, 11 o'clock a.m. Mr. Mader will need to be transported and be personally present, courtroom B, Butler County Judicial Center, for the in-person sentencing, February 27, 2026, 11 o'clock a.m. Obviously, Mr. Mader, a pre-sentence report needs to be done to determine your criminal history and other matters. You'll need to just fully cooperate with the pre-sentence investigator if you're contacted, okay?
Yes, Your Honor.
All right. Anything else that we need to address on Matthew Mader at this time? Ms. Pierce?
No, nothing by the state, Your Honor.
Mr. Watts?
I don't believe so, Your Honor. Thank you.
Very well. I do have the Chief CSO on this meeting, Sarah Wheeler. Sarah, did you receive the information regarding the date and time of sentencing and charges that were involved in the Matthew Mader case?
I did, Your Honor. I'm currently working on the notice of duty to register form that will be sent out to the jail for signature by the defendant. In order to successfully complete that notice, I will need the exact statute, including subsections, as that's required for that document.
How about if
Go ahead.
I'm sorry, can I just go ahead and email that to her, Judge?
Please do. The third amendment information would have that information in it. So,
Okay.
Okay. Thank you for doing so. All right. Anything else, counsel, that the court needs to address?
Not by the state, Judge.
No, Your Honor. Thank you.
Mr. Mayor, do you have any questions about what we've done here today?
No, Your Honor.
Very well. Then if there's nothing further, the Matthew Allen Mader matter will currently be in recess at this time, and the meeting may be.
With the no contest pleas accepted, the court formally enters convictions and orders a pre-sentence investigation, a report that will heavily influence how much time the defendant ultimately serves. The trial is gone. The verdict is locked. What remains now is sentencing and lifelong legal consequences. This hearing shows how plea agreements shape modern justice, often faster and more final than trials ever could. If you found this case as intense and eye-opening as we did, hit the like button, share your thoughts in the comments, and subscribe for more in-depth courtroom breakdowns and real legal analysis.